Everyone. As you know, normally if we're in person, we would do introductions, but that's just simply not feasible during a Zoom meeting. So I'm just going to welcome you all. A few notes that I'm going to give you before we get started with the formal agenda. And that is, first, I want to let you know that Lindy, Fred, and Michelle have been reappointed by the State Supreme Court for another 3-year term on the Access to Justice Board. So we're all happy to see that. And thank you, you three, for being willing to devote 3 more years on the board and the work. I want to say that Dave Keenan has been appointed by the board to the WISBA Equity and Disparity Workgroup. Thank you, Dave. And also at our working session this morning, the board appointed Dave Keenan to be our representative on the Race and Criminal Justice System Task Force 2.0. So Dave, it's a banner day for you today. Thank you for your service. I want to let all members know that the board this morning at our working session appointed Esperanza Barboa to the Public Trust and Confidence Committee. Thank you, Esperanza, for all you do and being willing to serve on that committee. Just a brief update. As you all know, the board is having a racial justice action plan, and I want to let you know we are working on that. Our committee has been working at getting an advisory committee going, and they reported this morning to the board, and they've got advisors from all regions from the state except for one from Wenatchee. So that work is ongoing. I'll remind everybody that this meeting is being recorded. So keep that in mind, not that anybody here would say anything that would be embarrassing to you, but I do want to give you that heads up that the meeting is being recorded. You all have the board minutes. There is one correction already made for the April minutes, and you can track that on page 10 of the materials. But are there any other changes, corrections, or amendments to the proposed minutes? Cesar.
Yes, good morning, Sal, thank you. In the May minutes, there's just a minor thing, but it states that NJP received $1.7 million from LSC as part of the COVID emergency relief funds. That's incorrect. It was 1.1. So
600,000 is missing, Cesar.
I don't know what happened to it. I mean, you know.
It's a nice new house you have, though.
It's expensive to go to the Bahamas at this time of year with single plane, single.
All right, that change will be made. Any other changes? Thank you for reading the minutes. All right, board members, the minutes as changed. If you are in favor of accepting those, raise your hands. Board members, any opposed? Any
Let the record show that Fred raised his hand.
Thank you, Fred. The minutes are adopted. All right, we're going to have a report from Jen Wardell on the Civil Criminal Information Gathering Report update. Jen, you have 10 minutes, Jen.
Okay, good morning, everyone. Can you hear me? My headphones are wonky. Okay,
yes,
thanks.
Very well, thank you.
I always wanted to be someone who didn't say that, but I just needed to say it. I will be brief today. I'll apologize for some limitations. As we want to talk about this interview process and report that was shared about de-siloing, but the team member who actually did all of the interviews has been on leave since the interviews have completed. So I have incomplete information myself, and I'm also losing my voice, but I'll be really quick. The reference report, including a list of interviewees and the questions that we used to guide our interviews, are, I believe, included in the materials. Really briefly, conducted about 20 interviews over the course of 6 weeks or so, and with a range of advocates who are working within the civil, criminal, juvenile, and child welfare systems, as well as community members who have been involved with those systems. Again, you can check the list of who was interviewed in the materials. These conversations were framed as pretty initial conversations, an effort to gather just kind of a sampling of a range of experience, rather than a comprehensive analysis of how all of the justice systems intersect. And the themes that came out of the conversations were really validating and confirming what we already know, and what pretty much everyone in this meeting already knows. So, clients are often cycling through multiple systems, and at the same time that they're experiencing the systems as very fragmented and confusing, there's also this kind of underlying recognition of the system as this kind of mysterious monolith. So it doesn't always matter, when you're navigating your own crisis that, this is what we call a given agency or who's tasked with what role. They're kind of holding both of those experiences of like confusion and fragmentation, but like you are all part of the system kind of sentiment that came through. Both the advocates and the impacted community members we talked with are thinking and talking about systems pretty holistically and emphasizing the need to address the root causes that are perpetuating the harm they're experiencing. So for instance, you'll see in the report one interview cited over-policing and under-resourcing in communities of color and poorer communities. Almost everybody talked about how other systems like education and healthcare and housing fail and are the cause that lead to intersecting with the justice systems in the first place. And underlying all of this is historical and ongoing racism and white supremacy, which is fueling racialized outcomes, where we're, again, as we all know, we're seeing where Black and Indigenous and communities of color are continuing to fare worse across most measures in all of these systems. So the questions that are out there, again, these are things that we all kind of already know. Questions around how can we bring together the power we have collectively? So that's including the vast knowledge and experience of the communities who continue to be affected and harmed by the justice systems, combining that with the technical knowledge and the power and access that attorneys and system actors hold. How do we leverage this combined power to look not only at mitigating and stopping harm once it's already been created, so to continue to stop the eviction process once it's already in motion, or support folks who are exiting from incarceration, but how can we do that while also trying to interrupt the systems that are creating poverty, racism, criminalization, incarceration, and things like that in the first place? These are huge questions that, many folks are, already spending their lives trying to figure out, right? But in addition to that, underlying all of this, we're hearing the community saying over and over again, you can't just tinker with the systems as they've been designed either, right? Like these are systems that were designed to work for some groups at the expense of others. They were designed to work for white families and communities, for those who are able to gain wealth and gain access to the systems. And so if we're building solutions without a fundamental reimagining of what justice can look like, we're just going to create harm more efficiently. We're going to get more coordinated, we might get more integrated, but outcomes aren't going to change without some of these bigger kind of values-based conversations driving the change forward. So the recommendations that came out of the report, I kind of hate that our outcome is often more conversation. We should have more committee meetings and more task forces. But again, these are really huge conversations and some more integrated and intentional spaces needed. This can be an opportunity, particularly to bring together some of the umbrella organizations and networks that are kind of operating sometimes in tandem and sometimes not. The Access to Justice Board, Minority and Justice Commission, Council on Public Defense, and not only bringing those potentially groups together, but also together with a range of mobilized communities who are impacted in different ways by the justice systems. We know there's lots of other conversations happening, related conversations, so we would definitely encourage some limitation of scope for this, focused on where the justice systems are or should or shouldn't be intersecting, and also trying to identify participants who can bring in information from their other kind of networks and other conversations that are happening. So we kind of left our recommendations a little open-ended at this point to suggest, basically, our task was to answer the question, like, is this something we should dig further into? The answer is clearly yes, and it will require some more concentrated work. So as a next step, the recommendation was to basically pull a small group of initial planners together who can identify who should be participating from the various kind of networks and communities who are most affected by this conversation. So just a quick last note to say thank you to many of you who participated in the process. These are really, really rich and robust conversations. We've captured a lot of information that wasn't put into the report that can be really valuable. From what I hear from Tara, every conversation was just unbelievably thoughtful and very in-depth and holistic. So we would be happy to kind of share out more as it becomes relevant. And since so many of you are even closer to the work than I am, I'm going to stop talking and see what thoughts and questions folks have.
Okay, questions or comments? Questions or comments?
Sorry, I'm in a meeting.
Questions?
Yeah, I'm not up for about 2 minutes though.
Esperanza.
Hi, thank you, Jen. Thanks for all the work the committee did. The only question I have is, what's the percentage of the folks, excuse me,
That's a great
going
idea.
back to the report.
Yeah.
What's the percentage of the folks, the communities affected that were part of the interviews?
Yeah, they're complimentary, I think.
I don't know that we did it by a percentage. We reached out to about the same number of kind of advocates and community members in terms of who responded. I want to say out of the 20, I think 5 or 6 identified as being an impacted community member.
Okay. Thank you.
I'd have to look again at the list.
Thank you.
All right, other questions or comments? Questions or comments? I'm looking around.
Why them up here instead of us going down there?
Elizabeth.
Okay.
Yeah, Jen, great work. This looks really awesome. I know how hard it is to put together one of these since we're about to go next on one of ours. But I just had a question about stakeholders. I didn't see any volunteer lawyers programs involved in the interview process or projected to be potential contacts. Are you planning on connecting with any of the VLP community on this?
Yes, for sure. And just a point of clarification, and sorry, if someone need to go on mute?
Yeah.
Yes, we're having background noise. If you are not speaking, if you can put your microphone on mute, that would be appreciated. Thank you.
Cool. Thank you. Yeah, just clarification on the potential contacts. These were just folks who were either we reached out to, but we weren't able to schedule something with, or that an interviewee identified as a next contact. So it's not a list of like everyone who should be contacted. We did have some conversation with KCBA, but yeah, it's definitely a missing perspective that needs to be included for sure.
All right, thank you, Jen, for that work and the report. Much appreciated, and I know it's going to be continuing on. Moving on to the next agenda item, which is the DISCO Undocumented Workgroup update. Chach, I see you here. Thank you for being here and giving us the report. You have 10 minutes for you and either you and your group to report on this.
Thanks, Sal. Good morning, everybody. Danielle and Elizabeth are going to jump in a bit, but we will also try to keep it brief. First, I wanted to thank the ATJ Board for giving us time to talk about our report. We assume you've read it, so we won't go. Can you hear me? Can you not hear me?
Yes, we can hear you.
Oh, okay. We won't go through it line by line, but what we do want to do is summarize some of the need for action from the ATJ Board at this point. And undocumented people in the state and country are excluded and discriminated against daily. And it is true for our civil legal aid system. Undocumented people are essential, yet they are expendable. And COVID-19 has really highlighted some institutional problems that we have. It's past time to stop this inequitable behavior, particularly in our legal systems. And I know that the ATJ Board recently adopted some priorities, and there are 2 that are specifically targeting this population. One that you adopted was addressing the civil legal needs of people without lawful immigration status. And the other was to promote systemic and internal race equity practices, working towards a vision that race or color does not determine the availability and quality of services, fairness of outcomes, or opportunities for communities and individuals. Our recommendations are in line with these priorities, and today the work group is asking that the ATJ board adopt the recommendations in the report as they are presented. And to briefly go over those recommendations, I'm going to turn it over to Danielle and Elizabeth.
Okay, thanks, Chach. I'm going to present, I'll just get started and then Elizabeth's going to wrap us up. So there's 5, as Chach said, we think you have seen them already. But to highlight them, the first recommendation for the board relates to being really clear about this being a community that we are dedicating, prioritizing resources for. And so we have several recommendations about how to do that, including supporting efforts to amend the OCLA statute to remove immigration-based restrictions, to specifically integrate this in an explicit way into our state plan, and to prioritize dedicating resources for this community, and increasing at this time, especially understanding it's times where we are really concerned about resources, which of course everyone is right now. This is the time to increase the investment in serving this community. So several recommendations about getting more clear with this as a priority and putting resources and organizational and financial to back up that commitment. Related is supporting Alliance members in taking steps needed to adapt their services to really meet the needs of this community. As Chach said, COVID didn't create problems so much as reinforcing and making more clear long-standing inequities. So we are aware that there's support needed for Alliance members to adapt the way they do, we all do our work to better meet the needs of this community. Even more profound a need now, given that people have less ability to see people in person, staff mobility is more limited, all the things that people know. So we think that assistance directly to Alliance members is another critical part of making sure that we are able to meet the needs of this community.
And then the next recommendation that we had, we definitely did a survey and we tried to talk to as many stakeholders as possible, but first, we know that there's areas identified by our undocumented community of requested legal assistance that are being underserved. And so we ask that we as an alliance really focus on those areas. One of which, is immigration, also language access is a big deal. And that is definitely permeates all of the different legal areas that we identified. But also to continue mapping efforts, not just in where legal services are provided, but what level and to what extent. We have historically relied a lot on the volunteer lawyer program community to serve undocumented people because of their lack of funding restrictions. But we also have volunteer lawyer programs that are covering, like 6 counties. And so what can they reasonably do to serve different people? And do they have the capacity to provide even full representation or, limited advice? So we'd like to see further work done at a regional level to map those services. We also identified a potential partnership with WISN, which is the Washington Immigration Solidarity Network. We all as the Alliance use and love CLEAR, but we know that people in our undocumented communities have a barrier to access with that, either just fear-based because they don't want to be asked about their immigration status, or knowing that or believing that they won't be connected to an appropriate resource because of their status. So we've been working with WISN to develop a partnership capacity to be able to field legal questions that come in through their hotline. And then finally, we really wanted to emphasize, because we asked not just legal aid partners, but just organizations that serve undocumented people across the state. And legal aid is crucial, sure. But right now, the concerns that our people have on the ground are, where is rental assistance coming from? Where is financial assistance coming from? There are basic needs that aren't being met because of barriers to access based on immigration status. And so, we aren't necessarily recommending that legal service providers provide these direct services, but that we rally around the need for them and emphasize that that those are crucial to keeping people housed and safe, and then be able to move on and access their legal needs.
Great. Chach, Elizabeth, Danielle, thank you for your work on this. Board members, this comes before you as a motion because it is a committee recommendation, so it does not need to be moved separately. So are there comments, questions for the committee members? Or any discussion on this item? Esperanza, am I seeing a hand?
Yeah.
Esperanza.
First of all, thank you for the committee for doing this work. It's extremely, extremely important. And this body is called Access to Justice Board, and we are not doing our job if we're not addressing a population that has been historically pushed aside, neglected, or not necessarily neglected from the legal, from this community here, but where people's hands have been tied to be able to support the community and provide the services that they need. And your first statement, Chach, about these are people who are necessary yet expendable, right? Who are labeled as essential, yet we can look the other way if their needs are not being met. And so being treated like the other, consistently being treated like the other, and we need to change that. And for any concerns of how are we going to do that, I think that those are good questions to ask, but they're not, they should never be the reason why we don't do what's right. And what's right is that we adopt these recommendations and then move forward to figure out together how we make sure that they happen. And as a daughter of a woman who was undocumented till the day she died, I am so glad that you did this. It's way overdue. So thank you.
Great. Thanks, Esperanza. Laura.
I totally agree with what SB just said. Thank you, SB, and thank you to the committee for working on this. My request is just, can you, either Chach or one of the other presenters, quickly summarize the proposals you're asking us to adopt? I got a little lost.
Sure. I can go ahead and address that. So what we're asking is that you adopt all of the recommendations as annotated in the report, 1 through 5. As they are. So, and at that point, once you adopt them, how you actually go and implement the changes is somewhat up to the, obviously up to the ATJ board. Did that clarify it?
Okay, I see a yes. That does clarify. Thank you, Chach. Any other questions or comments? Seeing none. All those in favor of adopting the recommendations, and I think as Chach and her committee said, these give us the broad parameters. The board will have to take work to actually follow through and take action on these items. But this gives us pretty clear guidance. All those in favor, raise your hand.
Fred Corbett's hand is raised.
Thank you, Fred. Any opposed? Any abstentions? Motion carries unanimously. Again, you three, I know this is a lot of work. I would watch the work from DISCO's standpoint, and I just want to thank you so much. And your work has brought fruition, not the end of the fruition yet, but certainly a great starting point for the board. So thank you again. Much
Thanks, Sal. I do want to add that also, if people are interested in talking about the 1B recommendation on the OCLA statute, there was a conversation, there have been conversations with a lot of people on this call about how to implement that. Either, since we have, if you have time, you can either address it now or at a future date, but I know Will has been working on that.
Right, and Chach, believe me, the board will be addressing that, but not today.
Great.
Okay, thank you. All right, Technology Committee update. And Laura has told me that Jordan Couch, and I saw Jordan's name up. I haven't seen your face, Jordan. Everybody who is on the Zoom, if you would show us your faces, that would be great. We all like to see your faces, but Jordan, you got 15 minutes. We have 2 action items and 2 reports. So hopefully.
Thank you so much. And sorry, I don't have my camera with me right now. I'm not in the office at the moment.
Gordon, you're like the tech guy. No matter where you are, you're supposed to have a camera.
I know. I took the week off. I've been out of the office. You know how it goes. But thank you so much for having me. As you did, I mentioned we have 2 things up for action and then just a couple updates to give. So I'll try to go through this in an orderly manner to make it easy on you. First up, we have a letter drafted in response to the sunsetting of the LLLT decision. As you can see in this letter, our push is we are not, trying to get the court to reverse themselves. What we're asking for them is to go back, look at this, and kind of have a more open discussion about this conversation with the bar generally and with the legal profession generally as we do this. I think even if the decision still comes down the same, that conversation is a valuable one to have as we think about what we need to do moving forward as an industry. So that's why we think this is important. And that's why we've proposed this letter to be sent to the courts.
All right, board members, this comes before you again as committee action. So it's a motion. The proposed letter you'll see at page 23 of the materials. If you haven't got it before you, it's page 23 of your materials. And I saw Terry Price's hand up. Terry.
Thank you, Sal, and thank you, Jordan. So just to clarify, actually the letter does say, please reverse your decision. Or it says, please reverse or suspend. Jordan, per your presentation, I think you're saying that you want the letter to say, please suspend your decision, and provide stakeholders the opportunity to engage, which is certainly a position that I would advocate for.
Yes, and the letter was said reverse or suspend, the idea being not necessarily that we tell them to permanently reverse, but that we go back and make this decision in a different manner, whether that means you reverse it or suspend it, one of those 2.
All right. Other comments? Thoughts? All right, so I'm going to weigh in here on this thing. And I think I've been pretty upfront about this in a lot of groups. Again, I look at who's on our state Supreme Court, and there are people who have committed their lives to access to justice. And I think of Steve Gonzalez, Mary Yu, Deb Stevens, who have been big supporters. And at least in my view, what limited information I have not been convinced that a LLLT program was one that improved access to justice, at least gave even a good bang for the buck, much less the biggest bang for the buck. And so I am against sending something like this unless we had some new information showing that, in fact, the LLLT program was making a difference. Certainly wasn't making a difference for the VLPs. I'm understanding there's only one VLP who has a LLLT employed, and that is out in Kashmir. So, and again, looking at the composition of the court, all they've done, and with the information that I have, I don't want to second guess their choice. It may have been, I would agree, I think probably the manner that they did it was not in the best manner possible. They should have opened it up, but be that as it may, I'm not in favor of this. Laura.
So, I was at the Board of Governors meetings and I heard all the reports about how much the program cost. And, I'm sure that was partly persuasive to the court. It was an expensive program. To your point, Sal, I think our letter is as much about process as the ultimate decision. It really felt, at least to the technology committee, that decision was made without really talking to stakeholders and without really considering what else we might be able to do. And so I think part of this letter is to ask the court to talk about the decision they made, the reasons they made it, and then engage in a continuing conversation about what can we do to help people who aren't getting representation through other avenues.
Other comments? Michael.
Yes, so I am the pro bono council manager. I work pretty closely with the VLPs. We actually did send a letter on behalf of the Pro Bono Council and the VLPs to the Supreme Court, suggesting that perhaps this wasn't the right decision. The VLPs don't all employ LLLTs, but many of them do have volunteers that are LLLTs, and they have been very stalwart volunteers and have contributed at a very high percentage. Almost, I think it was more than half of all the LLLTs that are licensed did volunteer with the VLPs. So the Pro Bono Council's position is that this was the wrong decision for the Supreme Court to make.
Francis.
I would have appreciated if that information is included in the letter to reflect the fact that our VLP are really using the LLLT. Like Sal said, it's really hard to be able to look at the letter and see how it advances access to justice. I'm for LLLT. I'm really for it, but we need to be able to, the letter need to reflect how much LLLT within the time of it that we have added, how much of it is being directed towards expanding access to justice in our state. So that is where I am. I wish the letter would reflect what Michael just said.
Other comments, Jim? And then.
So I'm going to spend a moment and remind people what the LLLT program was designed to do and why it fits squarely with the ATJ Board's charge. Even in the order and decision that adopted it back in 2012, 2013, the court acknowledged that LLLTs, basically because their model is a fee-for-service model, those in the private sector anyway, are not going to be a substantial addition to the efforts to meet the civil justice needs of the very lowest income people in our state. But the ATJ Board's charge is broader than that. The ATJ Board's charge is to promote access to justice for low and moderate income people in our state. And the LLLT program is best considered as one that serves predominantly people who are above 200% of the poverty guideline, but cannot afford the full cost of a private attorney for performing the tasks allowed under the LLLT rules. So on its merits, I think the court has as yet failed to assess whether the LLLT program is performing any of the functions that were anticipated, and if so, how well they are performing those functions. Second, I would say that the court's action, which is effectively overturning a standing court order and standing court rules by issuance of a letter, is unprecedented and inappropriate. And it also creates very bad precedent for other kinds of circumstances. Yes, I agree, we have great champions on the court, but even great champions make mistakes sometimes. And I think the court's, both the substance of the court's action and the process by which they undertook to implement that action were wrong. And they did make a mistake. And then finally, I just want to note that the letter itself is not self-executing, and even the clarifying letter is not self-executing. There are standing court rules that need to be amended or repealed, and that will require a GR9 process in front of the Rules Committee and then the full court. So it's quite frankly, it's a mess. And to the extent that this letter suggests that the court suspend that action and undertake an appropriate process to consider the range of substantive and budget-related issues related to this program before taking specific action, that is the preferred course from my perspective and my recommendation to you.
Esperanza.
Yes, I just, oops, yes. I just wanted to make a statement on I appreciate what you just did, Jim. Thank you very much, because I think that kind of covers the technical side of why that decision was not a good decision. And this conversation and that decision that it's not really meeting the needs reminds me of that story where somebody's walking along the beach and there's a bunch of starfish, and you know they're throwing a starfish in there, and somebody comes along and says, what difference is that going to make? Well, it makes a difference for that one that I just threw in, that it's going to survive. We are one of the VLPs that are fortunate enough to have triple LTs doing pro bono work with us. And I'll tell you that the difference that makes in the lives of the people who need those services and would otherwise not get those services, we're able to expand our services because of the triple LTs and their commitment to pro bono work. I think we just need to sometimes assist each other in making sure that we're making the decisions that will have the best impact to the communities that we say that we want to serve, and not do something like what's been done to education when something is considered special or it's different from quote unquote mainstream curriculums, and that's what gets cut, but it's also what is not provided the ultimate support that is needed in order for it to flourish and develop. And I think that the triple LT program is one that would even do more for communities, for people who are disenfranchised and aren't able to get the services, if we all would get behind it and provide the kind of resources that it needs. We all know there's not enough services out there. We should not be finding ways to cut something that actually works, and it does work. Thank you.
Other comments? Jennifer.
Thank you, Sal. As a triple LT, I also would encourage this board to support a letter from the ATJ Tech Committee. I'm a member of the ATJ Tech Committee, although I didn't participate in writing that letter, and I'm also a member of the triple LT board. And I think it may be helpful to, I'd really like to acknowledge what Jim Bamberger said. I think he summarized it very clearly, that triple LTs were designed to assist not only very low income people, but considering the moderate income people as well. And, I volunteer with ELAP. I have done that for several years. My partner in my law firm volunteers with ELAP. We are making a difference. We need many more triple LTs to make a big enough difference. It's been very frustrating at times. When the Board of Governors first voted to change the bylaws to include some public member seats and either a triple LT or an LPO seat, and then basically stayed the court's order until the bylaws could be changed to remove the triple LT or LPO seat and the two public seats. What I'm seeing, what's happening is the triple LTs aren't really, there hasn't been enough, and there hasn't been a way for triple LTs to have a very effective voice in the decisions that are being made about triple LTs and about what kind of options and what kind of access to justice are they actually providing. My firm has helped well over 100 clients. I can tell you that the vast majority of clients tell us, oh, I've gone to an attorney, I can't afford them. We hear that on a very regular basis. We are, I believe, strongly increasing access to justice. And I think, I'm as a member of the triple LT board, and I'm speaking for myself, not for the triple LT board here. We had actually gone to the Supreme Court in the board had gone to the Supreme Court in its annual meeting and actually requested to expand the areas of law that triple LTs could practice into unemployment and into housing, which we believed would have been a terrific way to help with what we think is an upcoming tsunami of issues that are going to be raised. And, I think that would have made triple LTs more attractive to hire by VLPs and other places like that don't tend to specifically only offer family law services. I think it may have actually made it easier for some VLPs to hire triple LTs. But anyway, I don't want to take up too much time here. Thank you for listening to me, but I do ask that this board support at least be a way for the Supreme Court to reconsider its decision or to allow more public comment about the reversal or the sunsetting of the LLLT license. Thank you.
Other comments, comments or questions? Seeing none. Okay, I'm going to call for the question. So the motion before board members is to send the letter as drafted. That is the motion, to let you know what your options are. If you approve the motion, the letter will be sent as drafted. If you vote against the motion, another motion can be made. So with that in mind, Francis, briefly, 30 seconds. Do you have a question or a comment? Unmute yourself. Unmute yourself. It's all right.
Sorry, thank you. Can I take friendly amendment now, or should I wait until the motion is seconded first?
Well, there's a motion before, so what do you want to do? And I'll help you out here.
To reflect the fact that this board believes that this process was fraught and needed to be suspended and restarted, I'm asking that the letter come from the board and not just send this technology committee letter, to have a letter by the board that reflects some of the nuances that were talked about today from Judge Bradley, from Jim, and from Jennifer, that all of these comments, this important comment, be reflected in a new letter that will be sent to the Supreme Court.
Okay, and Francis, what I'm going to do is I'm going to call the question as is, because what I'm thinking here is, because I'm thinking along your lines, I'd rather have this redraft. I agree with a lot that's been said about the way the decision's been made, about what changes and maybe how it should be evaluated. I'm very clear on my evaluation right now, what I know, but maybe there's more facts out there. But so I'm with you on this, but we have a current motion before us. So let's deal with that motion. Just so board members are clear on this, if you vote in favor of this motion, the letter will be sent as drafted from the board. That's on page 23 materials. If you vote against the motion, there's a chance for another motion along what Francis and I have just talked about. All those in favor of the motion before you, raise your hand.
Point of clarification.
Yes.
So once this vote takes place, then we're gonna vote again.
Well,
I just finished.
No. So Esperanza, if you vote in favor of this motion, unless someone tries to make another motion, this is the letter being sent out. If you vote against the motion, then there can be another motion as to another letter and what that would look like.
Mm-hmm.
I think is what Francis is saying.
And the people that put this letter together would also be part of putting a second letter together. Okay.
It depends on what the board wants. Let me make this clear. The board does what it wants to do. All right. You have committees.
I get that. I get that.
The board.
Yeah, I get that. I'm just saying that, you know, if we're going to do another letter, that the people that drafted this letter are part of it, and that it's something that happens quickly and not something that is dragged on. That's all. Okay.
And again, the subsequent motion can be made with whatever parameters people want. I just want to make sure that's clear.
Mm-hmm.
All right, with Michelle.
Yeah, I had a similar concern to SB, and this would impact whether my vote on the current motion, which is I know that this happened weeks ago at this point, and so I'm wondering about the sense of urgency in getting this out right away, because I do think that if there is a timeliness issue and we want to get something out sooner rather than later, then and what the reasons for that. But I'd like to hear the reasons and why that's important, because I'm fine with this letter if we just need to make a statement now. But I'm worried about kind of the bureaucracy and the process of drafting a new letter and how long that will take.
Right. And let me try to, what I think would be an accurate assessment. The sooner the letter gets out, the better, because it is, as you said, a time-sensitive matter. The more time that goes by, likely the less impact your letter will have. And that's all I'm going to say. I think if somebody wants to maybe have a different opinion on that, you can certainly do it, but we do have to call this thing for a vote, right? And then how quickly you can get a second letter out. Again, the board can set those parameters. The board can do what it wants to do. Okay? Well, whether it gets it done is another question, but the board can say, we are going to do X by X date. All right. Any other clarification points on this motion? All those in favor of sending the letter out, and it'll come from the board as drafted, raise your hand. Okay, I have 3. All those opposed to this motion of sending out this letter, raise your hand. Fred, how do you vote?
I'm opposing this motion.
Okay, the motion fails. Francis, I'm going to call on you just to keep this thing moving because we are already way over time. Would you like to make a motion? And I will help you out if you need it, but do it.
I'm capable of making my motion. Thank you, sir. So my motion is for the board to draft a letter that will include some of the information in this current letter. And I would be asking the board I'm nominating Judge Bradley to help craft the letter and that will reflect some of the discussions that we have had today. And that letter will be adopted by the board and will be sent as soon as possible.
Fred Corbett seconding the motion.
All right. Any discussions on the motion? Okay, I will repeat the motion. The motion is to have Judge Bradley work with the tech committee to draft a letter to include what was been discussed here, and this letter will get out ASAP. That is the motion. All those in favor, raise your hand.
Fred Corbett raising his hand.
Any opposed? Raise your hand. Any abstentions? Motion carries unanimously. All right, Jordan, well, you're going to have to buzz through your last few items. And the main thing is the letter support for JISC Rule 13 amendment. You would address.
I'll skip around a little bit to make this easier on everyone and save us time. So just the quick updates side of things. As far as tech tools for eviction, we are working with some of the local pro bono organizations dealing with the coming wave of evictions that we think are likely to happen to help them build tech tools that are useful for the future. So that is an ongoing project. Another ongoing project is with the Access to Justice tech principles being approved now by the courts. We are working on a marketing campaign to educate people about these and create resources, make them public, make them available, and make everyone aware of them so that those can start to be implemented quicker. Last thing on the list is the letter we have drafted commenting on the proposed changes to the JISC Rule 13. This is something that is solidly in the Access to Justice Tech Committee's purview. This is the kind of thing we were created to comment on. And this rule is basically helping us build a stronger, better technological future for the courts. One of the large issues to access to justice in this state right now, and this is not unique to Washington, is that court technology systems are not consistent, are not as easy for people to use. And so this rule would give more oversight on a statewide level and more collaboration on a statewide level to build better tools as we upgrade and implement new systems in our courthouses, as well as allowing us to streamline data. For those of you who know me personally, you know that data is a big deal to me and to my law firm, Palace Law, because I think that is an essential tool for access to justice, allowing us to understand the problems that our communities face on a universal level. And this change to the rule will help us do that. So we are writing a letter in support of this rule change.
All right. That again comes before the board as a recommendation, and you'll see that starting at page 26, I believe, your materials. And I'm trying to get my screen back up. I'm sorry, I had to switch over some things. I can't see anybody right now. So if you have comments or questions, yell out until I get my screen back.
Sal, I'll just jump in here. So I'm the ATJ Board liaison to the JISC. And I guess I've been doing that for 2 years. And all I will say in support of this motion, it is shocking to me how how different courts are developing like little mushrooms, their own data systems. And if we do not have centralized standards of how data is shared with among the courts, then warrants that are issued in a district or municipal court someplace are not going to go into a central repository. Similarly, LFOs that get paid are not going to go into a central repository. And so I strongly support this motion, because without data standards, our central repositories of data in the state are just going to be a mess.
Great, thank you, Tara. I've got my screen back up. Any other comments on this motion? Seeing none, all those, oh, Francis.
I just wanted to support Terry's position. As someone that works in Eastern Washington, we've seen that play out in different jurisdictions. Between the district court and municipal court, there are two different systems within the same county. And it's a mess, it's a complete mess. So I strongly support this position.
Thank you, Francis. Anyone else? Seeing none. All those in favor of adopting or approving the letter of support for JISC Rule 13 amendments, raise your hand.
Fred Corbett raising hand.
Thank you, Fred. Any opposed? Any abstentions? Motion carries. Thank you, Jordan, for your presentation. Much appreciated, and welcome back from your vacation.
Yeah, thanks so much for having me. I'm going to head back to it and maybe get some fishing done.
Good luck. All right, next we have a COVID-19 update from Alliance Providers. And I just got the name Moonwater. Diana, who is presenting on this?
Yeah, Moonwater, I think, is here.
I haven't seen
there.
it.
Yeah.
Oh, there. Okay.
Yeah.
Yep.
I'm here. Thank
Great.
you for
You've
having
got 10
me.
minutes. Thank you.
All right. Thank you for this time today. It's really nice to join you all. I had the opportunity to present. It's probably been over a year or two, perhaps, at one of your meetings in Bellingham. So nice to see you again in this format, and thanks for making time. I'm the immediate past president of co-president of Resolution Washington, and so my colleagues send their regards, and again, we appreciate the opportunity to share with you an update about what's happening statewide in the world of dispute resolution with each of our 21 centers throughout the state. So I can sort of start with a big picture just to let you all know that the 100% of us had closed our doors to the public probably by mid to late March and worked to pivot our services online. So we recognized immediately the significant need that was going to mount shortly in order to have our services be able to be accessed in a virtual setting. So we collaborated across the state in late March and early April in order to develop a mediation platform on Zoom. And at that time, Zoom was certainly going through their own growing pains. So we have worked together to develop new protocol and policies and a system in order to be able to comfortably offer mediation online to anyone in the state. And so we have successfully done that, and concurrently have been pivoting other services online as well. So we are, as a state, providing not only mediation services, but training services online. A handful of us who are providing supervised visitation are providing supervised visitation online. We're also continuing to offer large and small group facilitation online, conflict coaching, and other services as needed. So we've been able to successfully pivot on a bit of a shoestring budget. As you all well know, dispute resolution centers have been advocating for many years now to increase funding to support our network, because we have the services and we have the mediators and capability to provide even more support to our communities. But as with every other nonprofit, we're similarly needing to bolster the revenue and resources coming in order to strengthen the infrastructure that we have. So we're continuing to focus those efforts and trying to find creative ways to continue to support our work. And many of those creative ways involve focusing on collaborative partnerships, both with some of you probably here in this room through local civil legal aid organizations in various counties, as well as participating in statewide conversations and task forces that are focusing on very specific issue and challenge areas right now that are emerging as a result of COVID. So a couple things that I can share with you in terms of some of the specific work that we're doing now, and the question that was posed to me is for you all to gain a little bit more understanding of what we're witnessing and seeing with the clients that we're serving. So again, due to the onset of COVID, we all saw a general decline in the weeks following many of the closures that happened. But since then, things have started to increase significantly in terms of our caseload and demand for our services. Statewide, there's a significant ongoing and increasing need for clients to access parenting plan and marriage dissolution mediation services. This, I think, was in particular paired with the closure of the courts and the lack of folks' ability to move through the court system. They're turning to dispute resolution centers more frequently now to navigate those conversations with the assistance of our mediators. We're similarly seeing that with, here in Whatcom County, for example, parent-teen mediation is significantly increasing. So as you all well know, and if you have children yourselves, when you're isolated in your own home, and there's cause for additional conflict as we're all co-locating in much smaller spaces together. So, overall, we are seeing and hearing from our clients that there's increased conflict within the home. There's increased need for support to manage and problem solve in some creative ways, recognizing that that's only going to continue as these stay-at-home orders continue. So we're seeing an increase in landlord-tenant cases as well, and I can speak more to the eviction prevention work that we're doing shortly. We've seen overall a decline in our foreclosure mediation cases. The Department of Commerce, who serves as the funnel for that program through the Foreclosure Fairness Act, has seen that funnel sort of slow down, but we're all anticipating, as you all likely as well, to see a significant increase in the need for foreclosure mediation, especially as the eviction moratorium is lifted and the economy continues to be challenged for folks. So we're seeing increases in very specific program areas, along with unique and new emerging requests from the community at large. So there have been changes and increased requests for facilitation support as various community-based organizations and local government are trying to tackle how to address equity issues in their respective organizations and communities. So those difficult conversations and often tenuous and challenging conversations, folks are recognizing that they need assistance and support in navigating those waters. Here in Whatcom County, we've been providing some support to the city of Bellingham and Whatcom County as they are navigating a series of listening forums on race and justice here in Whatcom County. So we've facilitated 2 online forums so far, and we have 2 more scheduled for this coming Saturday and Tuesday. And so that's one way that our organization as an impartial facilitator is able to step into that space and help set some structure and create some additional safety for folks' voice to be heard. We are focusing quite a bit on eviction prevention work, and several of our DRCs have been providing very intentional programming and services in this area for many, many years. Others of us have historically offered landlord-tenant mediation that largely comes to us either through small claims court or independent community members outside of the court reaching out to us. But we're definitely aware of the looming need. The word tsunami was mentioned earlier, the tsunami of cases that are going to come as soon as the eviction moratorium is lifted in October. And as you all are probably following the governor's proclamations and the extension of that moratorium most recently, the encouragement and expectation and hope is that folks are starting conversations now and not waiting until that moratorium is lifted in October. And there certainly is a lot that remains to be seen about what is going to be happening, October 16th and onward. And it's not as if that's going to be a magical day where everything is sort of righted in the world. And so these ongoing issues are going to continue in a prolonged fashion. And we're highly interested in working to equip ourselves to be able to provide ADR support as early as possible. We have a colleague of mine is participating in the statewide unlawful detainer work group. Jim, I know you are actively a part of that. I think you've been working with LADESA, and thank you for that collaborative effort. I think we are very much just wanting to partner and see how we can support this continuum of services that we all know are needed now and are going to be needed for years to come as we feel the effects of this pandemic as it continues to be prolonged. So we're exploring how we can actively support early resolution through phone conciliation and other supportive efforts. The sooner the better, to successfully help people reach agreements, how we can work closely with our, both on a statewide level and then county by county with our local civil legal aid organizations, such as Law Advocates here in Whatcom County, on creating a continuum of services and making that clear and accessible to the community. I think one thing we feel cautious around and want to ensure is that the marketing and public outreach that's provided with these various service and access points are clear to the community, so we don't add additional trauma or stress to folks who are already struggling, and that there's clear entry points into these various programs, that we're partnering in a close and coordinated, organized way so we can have warm handoffs from one agency to the next. So those are the kinds of things that we're exploring now and in conversation with partners now. And DRCs are gearing up in terms of additional, although we've long been doing landlord-tenant cases, additional training both for our mediators and capacity building for our mediators, so we can be an effective partner and continue to be an effective partner in that continuum of services needed.
Let me just make sure that we're out of time. I want to give a couple minutes. People have questions or comments for you, all right?
Sure.
Questions or comments from Moonwater? Jim.
I just want, it's really timely, and thank you, Moonwater, for referencing it. At the Chief's request, OCLA and the Superior Court Judges Association have established an unlawful detainer work group that includes representatives of legal aid community, landlord community, and judiciary, designed to develop a range of resources, tools, and other products to guide courts as they, when the moratorium is lifted and evictions come. As part of that effort, we have undertaken to develop and hopefully invest in a program that will provide resolution specialists, eviction resolution specialists, and make them available to bring landlords, tenants, managers of rent assistance programs and other service providers together to solve mostly non-payment cases, rent non-payment cases, before they ever show up at the court system. It would be a significant diversion program. We're focusing on 6 pilot counties right now that represent more than 75% of the historical eviction filings. Resolution Washington is at the table on that project, and I believe that we have every confidence that the DRCs in those 6 counties will play a very significant role in hosting the eviction resolution specialists and facilitating meaningful outcomes that protect tenancies and ensure that landlords get some level of relief from the outstanding rent balance by tapping into state and local rent assistance programs. It's a great potential project. The group is working on an unbelievably short timeline and is working amazingly well. And you'll see the fruits of that hopefully by September 16th when we report back to the chief on the set of recommendations. I anticipate that the chief or that the court will issue another emergency order focused on this, and that the 6 counties will adopt standing orders establishing the eviction resolution programs in their respective counties.
Great. Thanks. Other comments or questions for Moonwater? Comments or questions? Seeing none. Moonwater, thank you so much for giving us that update and all that you're doing. We really appreciate it.
My pleasure. And thanks again for having me here today. And we just look forward to continued conversation with you all and the Access to Justice Board and OCLA and the civil legal aid community. We're here to partner and glad that we can work with you to serve our community. So thank you everyone for your time. I appreciate it.
Thank you. All right, liaison reports. ATJ board members, let's hear those reports about your liaison work. Here's the time. Board members, any liaison reports? Esperanza.
Just to briefly, I attended the Minority and Justice Commission meeting at the end of July. Was a very good meeting, very much focused on what the title implies. And there was a great report by a group that has been working on the issue of license suspensions, driver's license suspensions, and the impact, the huge impact to those members in the community who are hit with not only not being able to drive to and from wherever they need to go, but also all the fines attached to that, and how that connects to our civil legal aid work, and how they wind up in all of our VLPs. And so it was extremely enlightening to hear that report. There was a wonderful group from of law students who presented on the issue of reparations, which was also very powerful. And what was extremely inspiring was a presentation that was done by a community panel that discussed racism and the policing on Black communities, and it was led by Natika Oliver from Creative Justice Northwest. It took up the majority of the time. It was extremely powerful, a great panel with a lot of passion, and I appreciated very much the straightforwardness of the presentation that I think if it would have been done in person would have made some people feel uncomfortable, but kind of necessary the way information was presented. So I just wanted to report on that and how extremely powerful that meeting was, given the presentation by this community panel.
Thanks, Esperanza. Terry.
So I'm the ATJ board to two different groups, three different groups. So the Board of Judicial Administration has a court recovery task force to deal with reopening the courts not after the pandemic, during the pandemic. And there's a bunch of subcommittees, and I am now the chair of the Family Law Subcommittee for that group. And we have met a couple of times. The issue for our subcommittee is not only family law issues, but it's the subcommittee that has the most self-represented litigant issues on it. So we're talking about people who are privileged to have technology, people who are courthouses that are not privileged to have technology, and how that's going to, as we move to this concept of perhaps Zoom trials, how that's going to affect who's going to be able to access it and who is not. And there will be on August 25th, there will be recovery summit that is being hosted by the BJA that I believe that that people can join. A notice has gone out about that, and I appreciate Jennifer Ortega being on my committee. The other committee that I'm a liaison to is the 8 a.m. Wednesday morning meetings for the COOG, the Court User Workgroup. And Vonnie Dyseth from the AOC came and presented to the COOG a few weeks ago that the current data system since 2014 has had the functionality to be able to text litigants of their court dates and also to be able to email litigants about their court dates. And those two functionalities have never been turned on, ever. And so I'm not a voting member of that group. There was substantial resistance by that group to turn on what we would consider basic functionality in 2020. And my comment was, why should you get more service from your dentist's office than you get from your courts? And so that's an ongoing conversation, which I think is an access to justice issue. If you have self-represented litigants who don't understand the workings of the court, why can't they get a text message like their doctor's office? So those are two things that I think are access to justice issues.
Terry, thank you for reporting. Thank you for speaking up on that issue. You're seeing a lot of nodding of the heads on that second one. Other liaison reports? Other liaison reports? Any others? All right, seeing none. I'm going to move on to the next topic, which is the EJC, Equal Justice Coalition update. Will, I saw you earlier there. You are, Will.
Yeah, hi everybody. Thanks, Sal. I'll be pretty quick. A couple updates. The EJC continues to work on our communications goals that we've been working on throughout the pandemic, specifically some stuff with the Pro Bono Council and trying to figure out ways to get Pro Bono directors and staff onto the local news in a way that could perhaps be expanded throughout the Alliance. So I wanted to shout out Michael and Elizabeth and the Pro Bono folks for working with us on that. On the state funding side, I know Jim is going to give an update in a minute, but now that there is not going to be a special legislative session, or very unlikely to be, we're starting to get really focused on the regular budget session coming up starting in January. It sounds like there is a real opportunity not just to protect the current funding, and guard against cuts, but to actually get an increase to expand some of the emergency funds that came through the state to support, that OCLA secured to support those important efforts, and then possibly to fulfill the EJC's longstanding stakeholder goal to expand the funding partnership that passes through Funds the Alliance, which is more important than ever, especially this came up in the DISCO discussion the other day about ways to get more funding into the system that could support services for undocumented people, regardless of whether or not the effort to remove the restriction is successful during the session. And on that note, I just wanted to also say, Chach mentioned that some of us on the call had a conversation yesterday, Chach and Cesar and Caitlin and Jorge from NERP and myself with a few folks from CLS, sort of talking about what roles the EJC might play. As everyone I think knows, the EJC is traditionally not focused on policy issues. We're pretty laser focused on the budget. But what coordinating or strategizing complementary roles we can play with CLS and maybe even more importantly with advocates for the undocumented community like the Washington Immigrant Solidarity Network and One America and others. So I just wanted to see Murph, if you wanted to chime in anything about that conversation, and also say I really look forward to working more directly with the board now that the board has adopted the subcommittee's recommendations about sort of the next steps in that effort.
Murph, anything to chime in on there?
Yeah, it was a great conversation, and Columbia Legal is looking at doing this. We have to go through our process, but we should have a decision within the next week. We see this as really our role in the Alliance and what we're what we're funded to do, basically, which is to advocate in the state legislature on behalf of low-income people in Washington, and particularly people who are undocumented. And so we want to make sure that the work is community-led, as did everyone on the group, and make sure that there wasn't unreal expectations if it was passed, what it would mean for folks on the ground. And Jorge and others raised that as a serious concern. And so we're thinking about all of those, and this group will most likely continue to meet.
Great. Thanks, Murph. This is very exciting. And thanks for CLS hopefully taking on that work. All right. Thanks, Will, for the report. We're going to go on to funding reports. I'm going to go reverse order just to shake things up a little bit. So we're going to start with the Campaign for Equal Justice. Melinda, I see you on Zoom there.
Thanks, Sal. Good morning, everybody. I'm sorry I was late. I was actually at the kickoff for our 2021 King County Law Firm campaign, which is about a third of the revenue of the Campaign for Equal Justice. Natalia did a great job pulling together that group this year. We're excited to launch that. So far, the campaign has raised about $1 million this year. So we're on track to meet our goals. That's the good news. The challenging news is that we've canceled probably a dozen events like many other organizations around the state, but we have pivoted to a couple of exciting donor acquisition to reach new folks. We've launched an associates campaign for equal justice to work with associates in law firms, and a corollary campaign in the corporate sector to work with corporate counsel and some of our biggest and most supportive companies, Amazon, Starbucks, Microsoft, and T-Mobile. That's a pilot program this year that we're hoping to grow. So we're pretty excited about that. The Gold Mark, we have pivoted fully to a virtual event for February 5th, 2021. We hope you'll mark your calendars. Doug Baldwin is our keynote speaker. Nomination forms are out this year. For those of you, I hope you've seen those. If you have ideas for someone that you'd like to nominate for the Gold Mark, please get that in by, I believe, September 4th is the deadline for that. And lastly, as part of LFW's mission to provide resources to its grantees and to other Alliance members, we will be partnering with the community-centric fundraising organization. It's a new fundraising model that's grounded in equity and justice. And we will be working with them on a two-part series that we'll offer to grantees and Alliance members. The first one will be focused on fundraising staff. It'll be a training to help them understand sort of the new reality that we work in and raising money through a racial equity lens. The second series will be working with, we would actually like to invite in larger group of stakeholders and donors to have that conversation. So we're excited about that and look forward to sharing more information with you as we get it.
Great. Thanks, Melinda.
Thank you, Sal.
Caitlin from the LFW.
Okay, thanks. I want to apologize ahead of time. Today is my house is getting painted and it's very noisy, so I'm going to keep my report super brief and spare you the sound effects of the sanding that's going on right outside my window. In terms of an update from LFW, I would refer you to a letter that I posted on the ATJ listserv yesterday about 2:45, which kind of outlines sort of what we've done so far this year and where I think we're going. I think the big news in that memo is that in spite of a lot of uncertainty around our revenue sources, the LFW board decided as a response to the multiple pandemics that we're facing right now to just extend our existing 2020 partnership grants into 2021. So programs that receive annual support from LFW will not need to reapply for new grants this year. They're going to receive stable funding. Sometimes taking a leap of faith requires taking action outside of the boundaries of reason. And I'm pleased that the LFW board was in full support of this idea and unanimously approved the extension of our annual partnership grants. As Melinda said and Jay said, and we continue to develop resources, and we're exploring new opportunities and partnerships using this really challenging time as an opportunity to learn and grow. And we're looking forward to working with the Alliance to meet these incredible challenges that are in front of us. So that's all I have.
Great. Thank you, Caitlin. Good luck with the house remodel. Jim, report on the state level.
Thank you. So at the state level, we received and have contracted out $5.3 million worth of state and federal emergency COVID money. We have new partners involved. We have many components to the program, some of which have ramped up a little slower because of problems that we're experiencing with the Employment Security Department and the continuation of the eviction moratorium. But we've got boots on the ground, people ready to go. We have more than 65 private attorneys who are willing, able, and ready to do the work in the unemployment insurance space. In addition to that, we pulled in another $300,000 for emergency foreclosure defense work through the end of the year. The other money is feathered so that we can run it through June 30th of next year. The foreclosure money is only good through December 31st of this year. We have been having many conversations with a lot of folks about the state of the state budget. As you probably heard, there was a projected $8.3 billion deficit going into through the end of fiscal year 23. The Office of Financial Management has asked agencies to undertake 15% cut scenarios. The judicial branch is exempt from that. We are doing our own kind of analysis of where cuts might be taken without compromising, in our case, without compromising client services. Having been recognized as a frontline responder to the COVID-19 crisis, we are taking a very strong position that we cannot reduce services that the governor is already funding to stand up to address the COVID-19 crisis. But the short answer to the current question that we're facing is what happens after June 30th of 2021. The pandemic is not going away. I don't care what anybody says. And more importantly, the consequences of the pandemic are not going away. The recovery will be slow, it will be painful, and it will disproportionately affect low-income people, working people, and communities of color. And so we are now preparing a decision package, despite the budget situation, a decision package to continue our COVID-19 response efforts into the 2022-23 biennium. We don't know specifically how much that will be, but we will be shortly speaking with the EJC and others about both the magnitude of the request and the substantive focus of the request, with the goal of making sure that those who are most harmed by the COVID-19 pandemic and the economic consequences of the same have access to the critical legal assistance that they need to address those problems. So stay tuned. We'll let you know as soon as we figure it out.
Thanks, Jen. And then finally, Cesar on federal funding. Cesar?
Good morning again. Funding-wise, my only report is very nominal in the sense that the federal LSC budget for next year is sitting in limbo in Congress, but the House has approved a budget that includes a 5% increase in LSC funding for 21. Who knows when they're going to get around to that piece of it. There is an expectation that a second, I don't know, I forget what it's called, the next iteration of the CARES Act will have additional emergency COVID funding for LSC. Again, who knows where that lies. We do have we are in the process of absorbing and deploying the staffing that's been made possible as a result of the CARES Act and disaster relief account funding coming through OCLA that Jim referred to, and also including a number of temporary positions that we're kind of mixing and matching to make sure we have enough capacity on the ground in terms of both eviction, certain employment, and certain family services, as well as increased clear capacity, which has been our priority in terms of getting all those folks in place. We did have, and we've, with one exception, basically have hired up all of the expansion positions provided under the biennium. These were supposed to be sort of staggered between January 20 and January 21, but in order to ensure that folks would be available, we had started to accelerate those. So we're a little overextended on that side, but we do have all but one position in place. So very excited about that, and for working with Will and the EJC lobbyists and Jim in preparing for the challenge ahead to both maintain and hopefully expand the disaster services that are going to be needed in the coming years.
Thank you, Cesar. I'm going to go just a special little extra announcement from Nick Larson. Nick, are you still on the line somewhere?
I am somewhere here, Sal. How are you doing?
Here you are, Nick. Hope you are well. I know you want to talk to the board, so you get 2 minutes to talk about the WISBA Pro Bono Public Service Committee's action.
Thank you very much, Sal. Appreciate it. Just wanted to give everyone a heads up, if you haven't already heard, that at the July 2020 meeting, the WISBA Board of Governors unanimously approved a set of recommendations aimed at increasing the number of lawyers who opt for emeritus pro bono status under WISBA's APRs. And so these recommendations are now submitted to the Supreme Court. So we want to just bring everyone's attention to this, and I'm happy to talk more about it at a subsequent meeting or provide any information to anyone or through Diana to the board as we submit our proposal to the Supreme Court. The reason I mention it is because WISBA is submitting an expedited request to the Supreme Court to get these approved and in place for next year. And essentially what these do is, if attorneys who want to in the state of Washington practice a certain number of hours, that being 30 hours, in the previous calendar year, they would qualify for a waiver of their fees and be able to engage in pro bono work. So we imagine this will be a significant boom to the pro bono community and the pro bono work that could be done and is being done. And we're very excited about this, and we're very happy that BOG unanimously approved it, and we're hoping the Supreme Court will act quickly on it.
Hey, Nick, will you do me a favor? Send me the proposed rule, copy Diana and Bonnie on it. We'll have our rules committee take a look at it, and hopefully we can take action quickly.
Absolutely, we'll do that today. Thanks, Al. Thanks, everyone.
Thanks, Nick. All right, other updates and announcements? Updates and announcements, anything going on you want to let everybody know about? Any events? Seeing none. All right. I'm going to adjourn the meeting. Everybody enjoy the rest of this day, one of our last summer days. See you shortly.